Ladies and gentlemen, people of the Commonwealth, firstly I wish to show my respect and acknowledge my forefathers, our forefathers, who sacrificed their lives for our freedoms. I'm going to do a quick summary of Dr. Beverly Peers and Rod Culleton's matters, which have been joined in recent days, today being another hearing in the New South Wales Supreme Court. So let me try and explain how they have ended up there. On the 9th of April 2025, both their matters were heard in the High Court in Canberra at a directions hearing by the most newly appointed High Court Justice, Justice Beech-Jones. Rod's matter pertains to Section 92 of the Constitution, the people's ability to travel freely across our nation unhindered. This is the intercourse limit of Section 92. We can travel in a private capacity to visit friends, just to holiday across our nation. And the Constitution cannot be suspended even pro tempore, even in times of emergencies. Important to note that. That is from Greatwick versus Johnson High Court case law. So Rod's matter also is challenging the decision that was made in Palmer versus WA. The decision, they actually destroyed Federation, but at the time the matter was heard, the state of Western Australia had only been shut for a couple of months, not a couple of years. So the matter needs to be heard again. So this is a collateral attack on that for the High Court to make a decision now that all this time has passed, because circumstances have changed. Dr. Beverly's matter pertains to Section 109 of the Constitution. If the law of the state is inconsistent with the law of the Commonwealth, the latter shall prevail, and the former, to the extent of the inconsistency, is invalid. So, all of the state health acts around our nation in their practical operation were operating as state industrial laws. Now, the Fair Work Act of 2009 is a federal act that is king over the employee-employer relationship. At Section 26 of the Fair Work Act, it clearly states this act is to the exclusion of any state acts. It then gives the definition at 26.2 of what a state industrial law would be. So that is any state act that puts conditions in the workplace, regulations, or enters into, is involved with agreements between employer and employee. I'll give you the bare bones basics here. This is exactly what the Health Acts did with the mandate of this jab that they forced everyone to get in order to continue working. It became a qualification that was put in by a state act. So this in itself, as the Commonwealth have clearly said in the Fair Work Act, in the employee-employer relationship, this act is to the exclusion of any state industrial law, which means the Health Acts had no operation within the workplace. They could not mandate vaccination. The state acts also altered, impaired and detracted from the operation of the Fair Work Act because no one could go to work unless they had the jab. So there is both direct and indirect inconsistencies between the state's health acts and the Federal Fair Work Act. The Federal Fair Work Act trumps them, trumps all of the health acts. Dr. Vella is challenging the Public Health and Wellbeing Act in Victoria. Now, both Rod and Beverly's matters, the remedy that they seek within their matters is to invalidate, in whole or in part, sections of their relevant states' acts. So with Rod, it was the Emergency Management Act of WA. Dr. Beverly's matter is against the state of Victoria. So they both gave irrefutable arguments on that day, the 9th of April, to Justice Beech-Jones, irrefutable arguments as to why the matters could not be remitted to the federal court. Now, in Rod's matter, the federal court cannot open up and relitigate a decision of a higher court, a superior court. The federal court does not have that jurisdiction. The federal court, also does not have what is called territorial operation, the ability to invalidate in whole or in part sections of state acts. So these are extremely valid and crucial elements of their case. The federal court's got no jurisdiction to provide the remedy they seek, hence it's got no jurisdiction to hear the matters. This is where both Rod Culleton and Dr. Beverly Pearce then lodged into the High Court a jurisdictional challenge, as jurisdiction is a threshold issue in any court case. The jurisdictional challenge that was lodged into the High Court, because the High Court is the only one that can conclusively answer the question, does the federal court have territorial operation? It is the only court that can answer that question. It is also the only court that can reopen a decision of its own and rehear it, relitigate it, what have you. The federal court can't do that. This is the jurisdictional challenge that was put into the High Court that Adam Griffith, the High Court Registrar, rejected. So using 6.071 High Court rule, which is, he looked at the matter on the face of it and it was ill-conceived or frivolous, or it had no prospect of success. Rubbish. It is a jurisdictional challenge, and the only court that can hear the matter is the High Court. This is an extremely important and threshold issue of these cases. So for them, Adam Griffith to reject it, providing no intelligible or justifiable grounds for the reasoning, there can be no appeal made on a rejection with no grounds. So this is where a matter was then filed against Adam Griffith for perverting the course of justice. He provided no intelligible grounds or justification. His colleague Anna Bennett then did exactly the same thing using another High Court rule 6.072. She was emailed to confirm whether or not she had also used 6.07.1. And again, as her colleague had provided no intelligible or justifiable grounds for her decision. So both are guilty of that. Now, it is such a runaround, and I do understand when people may find it a little hard to follow, but this was the basis of why Rod and Beverly are in the Supreme Court now. Because the Supreme Court is to determine whether or not Adam Griffith and Anna Bennett are, in fact, basically, in layman's terms, guilty of perverting the course of justice and obstructing the people's access into the High Court. The Commonwealth created the Public Interest Disclosure Act. The name of the Act says it all, 2013. This Act is not there to protect Commonwealth officials. It is for the public as a reassurance, especially at Section 29, to hold Commonwealth officials accountable for their conduct. So we are in a situation now, it's just more and more time wasting, which is infuriating for me, very, very frustrating watching these cases go on. And I applaud Rod Culleton and Dr. Beverly Pearce for standing up for all Australians and doing this. So the Commonwealth are now trying to come in. They are just wasting time, basically trying to intervene in the matter or have themselves as named parties in the matter to protect the two Commonwealth High Court registrars, where they are Commonwealth officials. So this is where we are at. So, God willing, Chief Justice Ian Harris seems to be a man of integrity, and I hope I can have faith in what I'm seeing in him, that he is a good man and will make the right decisions. The Commonwealth cannot intervene in this matter as a named defendant, because this matter is against two Commonwealth officials, High Court registrars, as individuals pursuant to Section 29 of the Public Interest Disclosure Act. This is not a matter that is pertaining to any limits on legislative power. It is not a challenge to the validity of a Commonwealth Act. No, This is a matter where Rod Culleton and Dr. Beverly Pearce want justice. The jurisdictional challenge in the High Court should never have been rejected. So there is another matter that is looming to bring in a federal court judge and the state of Western Australia, for example, to directly ask them the questions. Can the can the federal court open up a High Court decision? No. They cannot open it up and rehear it and make a different determination. Only the High Court can do that. Can the federal court invalidate in whole or in part state acts? No, they can't. Rod and Beverly's matters need to go back into the High Court immediately. But instead we are now playing around with the Commonwealth, which is not surprising. Once again, stall tactics. So this is where we're at. Chief Justice Ian Harris will hand down his decision next week with this. So this is the thing, people. We've just got to get behind these amazing people, support them and watch what is going on in the courtrooms. We demand justice is not just done, but it is seen to be done. So we are the power. This is the truth evolution, and there's no stopping the truth coming out and coming forward. So step by step, we will get our country back peacefully and lawfully through the courts. Please keep your eyes on these cases. Ciao for now.